A couple of weeks ago, I made a video complaining about the fact that the Supreme Court of Canada refused leave to appeal in a case regarding the constitutional validity of mandatory breath testing in Canada. So in 2018, the law was changed to permit the police to when they pull somebody over, so long as they have a roadside breath tester with them, an approved screening device, a breathalyzer, roadside breathalyzer, that so long as they had them with them and it was a lawful stop, they could make a demand for a person to provide a sample into the device, and you're required to comply with that demand. And that was challenged because, is it a reasonable search and seizure? Well, it's not based on a reason. There's no suspicion or anything like that. Is it something that opens people up to being subject to the police abusing their authority? Yep, for sure. Is it dangerous that they're testing people and some people simply can't provide a sample to those devices? That's true too. And finally, your right to counsel, your right to talk to a lawyer is suspended despite the fact that you're detained, and that's a contradiction in the sort of constitutional application. And those were all our concerns with it. And the Supreme Court of Canada said, no, we're not going to hear it. Okay, all right, that's it. That law is now on the books, and it's not likely to change because that was brought as a constitutional challenge to the legality of that provision of the criminal code. But this week, the Supreme Court of Canada heard the actual application to the issue of whether or not the police can just randomly stop you. And this was in a circumstance of a fellow from, I think he was from Montreal. He was a young black male, and he just kept getting pulled over. Not getting tickets or anything, they just kept pulling him over. And so ultimately that matter got to court, and I don't know how it got to court because I don't think he was charged with anything. It might have been a lawsuit, not sure. But in any event, it's by the time it got to the Supreme Court of Canada, it was framed as a challenge to the police basically just randomly pulling people over, because at the Superior Court level in Quebec, the judge said, yeah, you know what, this is not lawful and there needs to be some different framework, and the Quebec Court of Appeal agreed. So went to the Supreme Court of Canada, and I suspect that they were looking at the leave application on the mandatory demand provisions and saying to themselves, you know what, mandatory demands, I think they can stand, but they've already, seen the argument at that point, seen all of the filings with respect to the challenge to the police arbitrarily pulling people over just for license checks and things like that. And I think they already had a feeling of that they wanted to revisit that, because I guess that is really where the potential for abuse is, less so than compelling people to provide samples. Although the right fact situation, I suppose that could change things, but it's not going to happen in the near term. So we will see what happens. It's called Luongo. That's the case. It was argued this week at the Supreme Court of Canada. Now we're just waiting for a decision on it. And we're going to find out whether or not the police can just randomly pull you over anytime you're behind the wheel just to suss you out, or because they want to, or without really any grounds they can pretty much make up as they go along. Check your license, check your insurance, check your registration, those sorts of reasons that really are non-reasons have been permissible in Canada for forever, and may not be when the Supreme Court of Canada renders its decision. Now we're just waiting for them to render their decision. It'll be big news when it comes out.